Okay, let's turn to the substance of our lesson today on discharge of contracts. There are many different ways to terminate a contract or discharge the obligations of the parties under that contract. We can kind of group these into five broad categories. One is by performance of the contract in some way. Another is if one of the parties or both of them breach the contract. Another is a group that we call by operation of law. Another is failure of a condition. And the last is by agreement of the parties of some respect. Let's first discuss in this segment discharge by performance, either complete performance or substantial performance. Complete performance of a contract basically asks, in other words, did you or the other party fully complete all of your duties under the contract? Did you do everything that was required under the contract, leaving nothing out? Generally, we measure complete performance by our very familiar reasonable personal standard. This is an objective standard. In other words, a judge or a jury is going to look at what has occurred. They would ask if a reasonable person concluded that the performance of that party's duties has occurred exactly as they required. But some contracts state right in the contract that a subjective standard is used. The test is, has the party performed to the personal satisfaction of the other party or to the satisfaction of the other party's expert? All right. When that is the case, personal satisfaction essentially means personal satisfaction. For example, if your portrait is painted and you're unhappy with that portrait, you might specify you're only going to make payment if the portrait's been changed to meet your personal satisfaction. However, even when the contract is to be performed to the personal satisfaction of a party, that party must act in good faith. For example, I can't say, I'm going to reject this painting that you made of me because it makes me look overweight. I am overweight. I can't reject it for that. I would be acting in bad faith if I did that. So there must be a valid reason to reject the goods or services. That party must act in good faith even when it's subject to a personal satisfaction standard. Now, some contracts, as I alluded to, also state they must be completed to the satisfaction of the other party's expert. When that's the case, typically there's an expert that's hired by one of the parties that is basically used to determine in more complex contracts whether performance has occurred. And probably the most vivid example of this, the most common example, is that of construction contracts. The American Institute of Architects has construction uh, contract language that they use in their form of construction contracts, and there's other organizations that use other different types of construction contracts. But in the American Institute of Architects, they basically use this language to define when the architect will review, when the architect is required to determine whether or not performance of the contractor's work is satisfactory or not. And here's the contract language. It's at the bottom of this slide. Based on the architect's evaluations of the contractor's applications for payment, in other words, certain work has been completed, a contractor desires a progress payment, the architect will review and certify the amounts due to the contractor and will issue certificates for payment in such amount. The architect has authority to reject work that does not conform to the contract documents. So the architect is the expert there, examining what is required in all of the plans and drawings and specifications. Those are commonly referred to as the contract documents. And does the work that was actually done by the contractor conform to that? And if it doesn't conform, then the architect can go to the contractor and say, you need to do this, 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 and this before you get paid. Even then, the architect has to have a reasonable justification for refusing to accept performance. Just because they're an expert doesn't mean they can act willy-nilly. Now, another question is, can a party substantially perform a contract and still get paid, or get paid most of what they're owed? Is complete performance always required? And the answer is no. Substantial performance of a contract can lead to basically the other party being entitled to get paid in most instances. The question is, has the performance that has been provided by the party not varied greatly from that which was required by the terms of the contract? And has that performance created substantially the same benefits? Again, we use the same objective reasonable person standard to determine if substantial performance has occurred, unless the contract calls for the subjective personal satisfaction test to be met. In either event, substantial performance only occurs if the non-completion of the work, not fully complete, or any defect in the work is not material. Courts will ask if the benefits of the contract have been received by the other party for all practical purposes, and as you can imagine, the outcome of each case is very dependent upon the specific facts of the case. Let's consider an example. All right. First, to state that the rule, all right, has variance basically been immaterial? Is it not a material defect? Has that party received the benefits for which that party has contracted? So let's discuss this case. Consider this example. Mr. Honig was meant to decorate and furnish Mr. Shepard's flat for $5,000. As you can imagine, this is a case out of England. When the work was done, there were problems with a bookcase and wardrobe, which would cost $700 to fix. So, a bookcase and a wardrobe that was specified to be in the contract is then not up to par. Mr. Shepard refused to pay half of the amount that was outstanding. Mr. Honig, who was the decorator and arranging for all this, sued to recover what he thought he was owed. Was this a case of complete performance? Obviously not. There was a problem with performance. There were problems with the bookcase and wardrobe. But was it a case of substantial performance? What do you think the result should be? Pause the video for a second and determine your answer before going forward. Was there substantial performance, and why or why not? Okay, let's look at what the court said. The court said when a contract provides for a specific sum to be paid on the completion of specified work, the courts lean against construction of a contract that would deprive the contractor of any payment at all simply because there are some defects or omissions. It is not every breach of that term which absolves the employer from his promise to pay the price, in this case the homeowner, but only a breach which goes to the root of the contract, such as abandonment of the work when it is only half done. In this case, Mr. Shepard, the homeowner, must pay the contract price, subject to a deduction for defects or omissions. Interesting. All right. Now, so the answer in this instance is that substantial performance occurred, and payment was required to be made subject to a deduction for the cost of fixing the problems that occurred. Now, I know what some of you are thinking. This is not fair because the homeowner didn't receive what he was asked to receive. But, you know, life isn't always fair in cases like this. Even though the homeowner has to expend some time and some effort to arrange replacements and then figure out the cost of that replacement and deduct that from what is owed, that's a consequence of contracting in our society. Sometimes other people don't fulfill their bargains. They don't fulfill their part of their side of the contract fully, And as a result of that, yeah, we incur unneeded time to basically arrange replacements. Now, let's consider another classic case in contract law. Uh, a homeowner and a contractor entered into a contract for the construction of a country house. In that contract, it specified the contractor must use reeding pipe, a specific brand of pipe. The contractor, however, inadvertently used the wrong brand of pipe. It wasn't reeding pipe, it was another brand. But there was little, if any, difference in the quality of the pipes. The homeowner sought to require the contractor, after all the home was built, to repair this defect. Now, this would have required the contractor to tear down walls, tear up floors even, to replace all of this pipe. The homeowner refused final payment of $10,000, which at the time was quite a lot of money. The contractor sued, stating that performance had occurred. Well, then the question is, has complete performance occurred? Has substantial performance occurred? Who's going to win here and why? Pause the tape for a minute. Okay, so let's go on and see what the court said. This is out of a 1921 case here in New York, okay? And the court said substantial performance occurred. While the defect was insignificant, is what the courts found, because of that, the court will find that substantial performance existed and excused the breach of contract because the same quality of pipe was used as the parties had specified. Now, the measure of damages in this case was not the cost to rip out the old pipe and install the new, because the court wasn't going to require that, but the difference in value between one pipe and another, which in this case was $0. So in this case, the contractor got paid everything that the contractor was looking to get paid. Now, I know what some of you are thinking. This is not fair because the homeowner did not receive the precise type of pipe that the homeowner specified in the contract. But the test for whether substantial performance occurred is determined based on whether the homeowner received essentially what the homeowner bargained for. Another way of looking at this is to ask, was the use of this other pipe a material defect? It is only material if it matters to a reasonable person. In other words, does it affect the quality of the work? In this case, the court concluded that there was no real difference between the brand of pipe that was expressly called for in the contract and the brand of pipe which was actually installed. Now, consider this though. What if the facts had been different? What if there was a significant difference in terms of quality? For example, what if the reeding pipe that could be expected to last for 100 years, but the pipe that was actually installed would only be expected to last for 50 years before it had to be replaced? In that instance, the homeowner might prevail, and the cost of replacing the pipe, however much it cost the contractor, would still be able to be recovered by the homeowner or be deducted by the homeowner in that final payment. So let's just review this whole concept of termination of a party's obligations under a contract by performance. That party can completely perform a contract, all right, or they can substantially perform the contract. Most contracts are subject to this objective reasonable person test as to whether complete or substantial performance occurred, but some contracts are written so that the performance of the duties of one of the parties is subject to the other party's personal satisfaction or to the personal satisfaction of an expert. In those cases, the other party or the party's expert can reject the contract, but then only for a valid reason. They have to act in good faith. The key for you in all of this is to be aware that complete performance of a contract, while it's certainly something that you expect in the world of contracts and in your dealings with other parties, is not always necessary to occur. Substantial performance can be all that is required. Needless to say, this doctrine of substantial performance leads to a lot of disputes in the world of contracts and a lot of litigation involving all different types of contracts.